On June 18, 2015, a man suffering from mental illness was reported missing in Orlando, Florida. Although he was later found, no details were available. That man's name was Cody Lee Jolly. Cody's story picks up again in 2023 in Missouri. After multiple arrests for trespassing, assault, and public intox, Cody was arrested on August 1, 2023, and charged with indecent exposure. Cody was released on minimal bonds and failed to appear in court, resulting in warrants for his arrest being issued. Today, Cody appears before Judge Simpson in Washtenaw County, Michigan, leaving us with one question. If a person with mental illness represents themselves, who will request a competency evaluation?
Court calls the case of the people versus Cody Jolly. Hello, what's your name?
Cody Lee Jolly.
There
was no counsel, please.
How did that happen?
I was representing myself.
Some people are really fucking stupid.
You're going to represent yourself?
Yes, Your Honor.
Okay, so what do you want to do today?
Is this pre-trial then?
This is a probable cause conference.
Probably.
That concerns me if you don't know that and they're going to represent
Yeah, I'm
yourself.
going to plead not guilty in this case.
Okay, you already entered a plea. What are you going to do at the hearing today?
The hearing today,
Yes.
I'm just going to plead not guilty.
Okay, that's you've done that.
Right.
So what do you want to do with this case?
I mean, it's up to you. I'm not understanding what.
No, you're not. It's not up to me. You
Pleading
tell
not
me what
guilty
you want to
to
do.
pre-trial.
Pardon?
My hope was to take it to pre-trial.
Well, the next stage will be a preliminary examination. Is that what you want?
Yes, Your Honor.
Do you know what that is?
Yes, Your Honor.
What is it?
The preliminary hearing.
Yeah.
It's another case similar to this, and then there's other options. If I'm seeking discovery, or if I'm seeking this, if I'm seeking that.
Oh,
For trial. For trial, right?
Is there a reason you don't want to be represented by an attorney?
Yes,
Because
Your
I
Honor.
see this thing
I've
going south real fast.
I've represented myself before, and I prefer to, Your Honor.
Have you requested discovery?
I have not.
Why not? You're here at probable cause conference. Why haven't you requested discovery?
The for me, there was no issue, there was no conflict, there's no case. There's no case whatsoever.
You requested discovery. Do you know what discovery is?
Can I request
Do you know what
today?
discovery is?
Yes, Your Honor.
What is it?
All the evidence in the case.
Okay, have you requested that from the people?
I have not.
Then how do you know there's nothing there?
Can I request a no?
You're gonna have to do it in your own way to request it. I mean, I can't help you through this process.
Would you like it by mail?
Represent yourself.
I'd like to represent myself, Your Honor.
Then you're gonna have to request discovery.
Do you want me to request discovery?
I don't care what you do. I'm just telling you, if you're gonna represent yourself, you're gonna need to request discovery. You haven't even requested discovery.
I currently am right now. If you'd rather me do it by mail, I can do it by mail.
Well, there's a way in which you do it.
I understand. You got to file it to the circuit, or to the circuit court, to the prosecutor,
for Pete's sakes.
and also to the
yes. That is not how it happens.
In front of you, then is the other.
No.
Okay, how does that happen? Sure. Then,
I'm not here to help you.
I understand.
I'm here to set the case.
I filed for case of study.
Okay, so here's what we're gonna do. People have their witnesses available on the 12th?
Yes.
Okay. That's what we'll do.
He was made aware of his constitutional right to an attorney, and he's officially.
He was made aware of that before.
Just making sure that it's on.
And he wishes to proceed forth. Is that correct, sir?
Yes, Your Honor.
You understand the dangers in representing yourself.
I do understand.
Did you want counsel to help you?
No, I do not. Not this time.
Your Honor, and just for the record, so that defendant is aware, he is charged with 2 counts of criminal sexual conduct that is a high court misdemeanor, punishable by up to 2 years and or $500.
You understand that, sir, right?
Yes.
Yeah, I'm gonna do it. Let's not send it for free then. Do you know how to, you don't even know how to go about getting the discovery on this case, do you? Do you want to talk to somebody about how to try to get your discovery on it?
I can honestly do it myself. If you'd like me to discover, I can file for discovery.
You don't even know how to do that.
Okay,
Do you know what you do to get discovery?
Before, usually when I file most, I file them by mail or in front of the judge, or I request a deed.
Okay, look. Trying to offer you somebody to talk to so they can show you how to get your discovery.
But
would you like to do that? So how do you intend on getting your discovery? Because you file a motion and you haven't requested it as a prosecutor, I'm not granting it. You're going to be wasting everybody's time.
Okay, so if you don't accept it by mail or in front of you, in what way would you prefer me to file for the motion?
Oh, for Pete's sakes.
Every judge is different, so.
No, every judge in this county isn't different. Welcome to Washington.
I've been to Washington, I think. Fortunately. No.
Would you like somebody to help you at least tell you how to get discovery in this case?
If someone wants to tell me, that'd be great, but I still prefer to represent myself.
I don't care if you represent yourself.
What's wrong?
I'm asking you because you have no discovery. You're going to walk into a preliminary examination,
Yes, if you,
and it's going to be a problem.
right. If you prefer it to be,
I don't care.
Motion be
I'm not.
differently
It's
than
not an
myself.
issue of my preference.
Okay.
I'm trying to get somebody to help you before you become an absolute disaster regarding this case. So I will make the offer again. Would you like to talk to somebody about how to get your discovery?
I would love to talk to him anyway.
Mr. Gaddy, will you please speak with this gentleman about how to get his discovery? I would appreciate it. Oh, I'm not passing. I'm just going to give a new date.
Oh, okay.
Because it's not going to come back up here before me, not today. I'll adjourn this matter to March 21st. Bond will continue.
Yes, Your Honor. I have a question for you, and I have a tether that's on that I can't afford. Is there any way that was just because of stipulations of ROR? I'm wondering if it's possible to remove it.
To remove the tether?
Yes, Your Honor. Since I'm not a flight risk or anything, I'm just living in town.
Denied.
Yes, Your Honor.
Thank you. Bond will continue. Okay. So 1 o'clock. I'm gonna need a break. Even if it's just 5 minutes. Court is standing brief recess.
Three weeks later.
Court does call the case of the people versus Cody Jolly.
Apologies on behalf of the people.
Your name, sir?
Cody Lee Jolly.
All right. I think this is people's motion.
Yes, Your Honor. I'm handling this for Ms. Willenbring. There is sensitive information in the police report that includes victims' contact information at home addresses and birthdays. So pursuant to the court rule, Ms. Willenbring would like to redact that information from the police report, but is requesting order from the court for that effect as well.
All right. First thing, Mr. Jolly, you are going to continue to represent yourself, sir?
Yes.
All right. I just want to advise you that there are 2 counts on your complaint of criminal sexual conduct in the fourth degree by force or coercion. You understand that, sir?
I understand what the charges are, but never.
Okay. Sir, I have to advise you.
Okay.
You understand that?
I understand.
And that those are high court misdemeanors punishable by up to 2 years incarceration, $5,000 fine plus court costs, mandatory HIV and STD testing.
Okay.
You understand that, sir?
Yeah.
All right. Sir, you wish to continue to represent yourself. The court does have to just advise you and admonish you that I will hold you to the same standards as I would hold somebody that is licensed. You have to abide by all of the court rules, etc. You understand that?
Yeah.
All right. And that you won't get any favoritism, and that the court is not in a position and will not assist you if there is something that you don't understand. You are going to be charged with knowing court rules and procedure. You understand that?
Right, I do.
All right. And well, I would also tell you that you do have the right And if you'd like an opportunity to consult with either a retained lawyer or somebody from the public defender's office, the court would make that occur.
Okay.
You understand that, sir?
Sure.
Do you have a response to the motion from the people?
I mean, my understanding then is they're gonna retract the name, the identification of them, but I'll get the rest of the information, is it correct?
You would get the rest. My understanding is any identifying information other than name,
Okay.
like address, any phone numbers, anything along those lines would be redacted. Do you have any problem with that, sir?
No, I have no use for that. I guess
And what I would indicate is that I will grant the motion as filed by the people. And there's also a request, I guess, that the motion hearing will be sealed and preserved for review in the result of an appeal.
I mean, yes, because that's what the court rule says. It's a funky court rule.
It is.
Because I haven't said their addresses or phone numbers out loud. It's just that the court rule says that if we're going to redact, that this hearing then becomes sealed.
Yes, it does. It does say that. So, I mean, I'll order it because that's what the court rule says. However, none of that information has been provided on this record. So the record is clear. All right.
Okay, I have a question, Your Honor. Like I said, I have no awareness even of an incident or any conflict occurring at all. I've been obedient I've been good on the tether so far. I talked with Brandon Casey, they're my case manager across the street. He thought that I wouldn't have a problem getting off after the first 30 days here.
I'm sorry?
The tether that I have, I mean, I'm a member, I haven't been in trouble. I've been here for years. I don't have, something to fight, but
So what are you requesting?
that I get this tether off. It's over. It's only fair. I mean, I've not been in trouble at all in Ann Arbor ever since I've been here. I've been in trouble at all. Not on probation. I have nothing to do with being a trouble with the community at all or anything like that. No witnesses. We grant that, please.
Given the circumstances, at least as I understand them, and because I haven't heard the entirety of the case or anything.
Right, exactly.
I'm
Probably cause or anything.
going to deny your request. Continue.
Why?
Excuse me?
John?
Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
That concludes this hearing.
3 weeks later.
Court does call the case. The people of the state of Michigan versus Cody Lee Jolly. We're actually set for, what are we set for? We're set for PCC. All right, state your name, sir.
Cody Lee Jolly.
All right. Mr. Jolly, are you still intending upon representing yourself? All right. I do have to apprise you that in this matter, you were charged with 2 offenses versus criminal sexual conduct in the 4th degree. Well, 2 counts as criminal sexual conduct in the 4th degree. You understand the nature of those charges? You understand the allegations as explained to you during the course of the arraignment in these cases? Okay. The maximum penalty, those are both high court misdemeanors punishable by up to 2 years incarceration, $500 fine plus court cost mandatory STD testing. You understand that, sir? All right, you understand that there can be great peril in attempting to try to represent yourself in a criminal matter of this nature? And you understand that the court would hold you to the same standards as I would any licensed attorney in terms of court rules and in terms of court procedure. You understand that? And you understand that the court is not going to try to assist you or help you out in any way? All right. And you understand also, sir, that if you are indigent and cannot afford to hire an attorney, that you would be afforded counsel and could request counsel at any particular time. You understand that?
Yeah.
Okay, very good. All right, so what are we going to do in this case?
Your Honor, I'm covering this case for Ms. Reiser today. She did provide me with the outstanding CD of discovery for the defendant. I understand that the police report has already been sent out to him by mail. The CD provided to the jail staff.
Yeah.
If the answer is no, I don't know how else. Okay. Could you put it in? Is that acceptable? Is that okay with you guys? Okay, thank you so much.
All right.
So that's
Oh.
everything we have.
All right, that's all discovery. Sir, what did you want to do next on this case?
Before I guess start the trial.
Well, you understand that the next step is not that of a trial?
Is this pre-trial?
Oh, okay.
I understand this is pre-trial and we're on the trial.
Mr. Jolly, do you really wish to represent yourself in this matter? I'm a little bit concerned because you don't. Well, but that's not how it works. Okay? That's what concerns me. You're charged with a high court misdemeanor. Okay? The next step is that we're at a probable cause conference. The next step is a preliminary examination. Okay? And then if you're bound over, then you're going to go through that process once again on the circuit court level. You follow that? Okay, so now understanding that that's a basic procedure, what do you want to do?
Just move forward and just not guilty. Case with preliminary examinations. It's okay. I have this matter. I'm in custody right now. And I was hoping to sell it to solve that.
So you want it, you got a copy of the police report, right?
I got the discovery. It was emailed to me.
Okay. So you want a preliminary examination in this matter?
If that's the next step to move on to trial, then I'm trying to get the trial done as fast as possible, but if the preliminary examination goes before that.
Wow. Yeah. All right. I know, but if it has to break, we just have to break.
Yes, sir.
All right. Set preliminary examination for April 23rd, 2024, 9 a.m. That will be before me. That's in person.
In this matter, the custody includes it.
Pardon?
The other day I went to the arraignment. I was hoping that to get released, but there was, I had to come here first.
What do you mean you?
He was arrested. My office had a new warrant request for him from the University of Michigan. It was for trespass and for violating the conditions of Your Honor's bond and that you said in this file. He has historically been trespassed from the University of Michigan libraries numerous times. He was again there, which is where he was arrested on April 5th, 2024. He was he was publicly looking at inappropriate photos of women in the school library, and other people were able to see what he was doing. He was reported when the police came. They recognized him. They recognized him as the person that they had trespassed times. The report indicates that his shirt was open, exposing his chest, and that his pants were pulled down, but that his genitalias were not exposed as far as they saw. Certainly this is the CSC. He's out on bond in the CSC case while he's engaging in this behavior. At the very least, the ongoing trespass is a violation of his bond, given that he's committing a new crime while he's out on bond, and that's concerning behavior in a public place, in a place he's in trespass. My office denied the warrant request, and essentially turned to this case and for us to move forward on violation here instead.
All right, sir, you are entitled to a hearing regarding a bond violation on this matter. Did you want to have a hearing on that? Did you want to admit the violation, or did you want to deny it? What do you wish to do?
To admit the violation was what again? I'm sorry. The violation was because when I got here, they told me that everything was. They said that it was when they came out and gave me this trespass. When I got here, they said the trespasses and stuff, and they weren't worried about it. It wasn't.
Well, they weren't worried about it from the standpoint of new charges.
Okay, yeah.
But my understanding is that the prosecutor doesn't want you released because what the conduct that's alleged to have occurred is a violation of the condition of bond on this case.
Okay, yeah, there was nothing inappropriate besides being in the library. Yeah, nothing weird in the library. I have no idea. But yeah, it wasn't.
But you weren't supposed to be back on the property.
That's what they said. I guess that was stemming from this. So,
do you want a hearing on it? Or are you going to admit to the violation? What are you going to do? You're entitled also, sir, to have a representation of an attorney for a bond violation here.
Right. I mean, if it's not a new charge, I admit that I was trespassed. That I was probably trespassing there. I was hoping to get out of jail for days.
Well, I need you to understand that I'm not agreeing that you're going to get out of jail at all. Whether you admit it, do whatever. I'm not. Well, you just admitted to the violation. That's why I'm worried about you not having an attorney. Just you admit to the violation of being on University of Michigan property, correct? Okay, so that's why I'm worried about you not being represented by an attorney. Because that's a violation of the bond conditions that I set in the case involving the criminal sexual conduct.
In a public library, I've never been there before. I wasn't aware that I wasn't allowed to be in a public library. I've never been in the building before.
Sir, did you want a hearing on the bond violations? Because I'm going to take into account everything that they're indicating, that you were trespassing and what was in there. Do you want a hearing on that?
Yes.
Do you want an attorney to assist you regarding that hearing on the bond violation?
I think I'm okay. I just the bond and stuff, we can get it heard. Simple as that. I've done 10 days in jail already. And
where are you coming up with this 10 days in jail? Yeah, but what do you mean I've done my 10 days?
I've done 10 days so far, and I've not actually had the charge. I've been charged with these 2 counts that are here, but I've not actually committed the offense.
Okay, but sir, you understand that the criminal charges that are here, that your release on those criminal charges, there were certain conditions regarding your release.
Right, that's what the tether.
Correct. In certain places you couldn't go, you couldn't leave the state of Michigan, no alcohol, all of that stuff, right?
Best I can. I've been 2 months without a problem. Best I can.
Okay, but now I have I have a trespassing, which is a violation of the conditional, your release. And I could, if there's a violation of the conditions of your release, I could certainly let you out. I also could just hold you until this matter gets resolved. You understand that? And now you want a hearing on that. And that's fine. I don't have a problem if you have one, you're gonna have a hearing on it. But then the issue becomes, are you gonna try to handle this hearing yourself? Or are you gonna want an attorney to assist you with that? I understand that you want to move forward, but there's gonna be a hearing that's going to determine whether or not you're in custody. Pardon?
As soon as possible.
Well, I haven't set a date. I'm trying to figure out how you want to proceed on it.
Just like I said, I'm just doing my best to live my.
Sir, I understand all of that. Listen closely to my question. This hearing on the conditional bond violation could determine whether or not you're in custody or you're released with other conditions or not, pending the further proceedings in this case. Bottom line, I could come to the decision, okay, well, I'm gonna let him out, put conditions on you and you walk out. Or I could come to the decision, no, he's gonna be held on this case. I'll give him a bond of some type, but he's gonna be held. Okay, but you understand what I'm saying?
Yeah.
You'd be held. That's what's at stake.
Yeah, just hope to get out as soon as possible. So I just like to move forward.
Well, I understand that, but follow what I'm saying to you. You say you want a hearing. My question to you is, are you going to try to do this hearing yourself, where one side of it, you might get released, the other side of it is you might be locked up for the remainder of this case? Do you want to try to do that yourself, or do you want the assistance of an attorney to help you through that process?
I think I just hope that just. Facts.
Just answer my question. You're gonna handle it yourself. Okay, but you're going to handle it yourself. How soon could we have witnesses available for a bond violation here?
Answer that question. I apologize.
No, it's okay.
Are you thinking like a week? Is that what you mean?
I'm thinking sometime next week, and then because the following week is what day?
So we would have Tuesday morning available, but.
The 16th.
But he's in custody, so I would do that. Because that's pretty much he's in custody. Once we did it.
What, I got stuff Tuesday afternoon.
You have an expungement docket at 1, which is small, so you can do it at 2 o'clock.
I could do it at 2 o'clock on Tuesday, the 16th.
It's a U of M police officer, so I can email him to U of M police officer, so I can email them and see if one or both of them can be there on that date.
Okay, what I'll do, I'll just set it. If there becomes a problem, we'll communicate with the defendant as well as you, just try to arrange a different time. So set a bond violation hearing, April 16th, 2024 at 2 p.m. At 2 p.m. There anything further, sir?
With the bond, yeah, that'll all be discussed as part of the tender condition. Because this time, this will be 10 days, it'll be like 15 days, and by the time that happens, I was hoping that would count for something, as far as the conditions of my bond. And I can't afford cash bonds, or something, just write a PR on it, maybe sign that, got it.
I don't know what you're asking me.
If the tether situation could be addressed on the same day.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so all right. I'm going to assume that there's nothing else. Bond will remain revoked. Thank you.
2 weeks later.
Court does call the case of the people of the state of Michigan versus Cody Lee Jolly.
Good afternoon, Your Honor. Pull up something else.
Your name, sir?
Cody Lee Jolly.
All right. This is a bond violation hearing. Just go ahead.
Before we begin, I do have a copy of the police report outlining the violations, a copy of the complaint of violation release, and 3 photographs all to give to the defendant so that he could review them before. Like, there's a paper.
All right.
Thank you.
Twenty minutes later.
Mr. Jolly, you had an opportunity to look through all of that?
Yeah.
All right. So let me ask you this. Do you still wish to continue with the hearing, or do you wish to admit to a violation of your conditional bond? As the court understands that there would be 2 potential violations, the violation of the substance abuse or substance provision of your bond. The other would be not to commit any crime, as there is the crime of trespassing, which has occurred or appears to have occurred.
Well, question, I guess, then, but just if I wasn't charged with trespass and stuff, right? Because I've not been.
I understand that.
Okay, so then would that technically come into play as legally? As
The condition of the bond is that you not commit any crime.
right.
Trespassing can be crime. Doesn't matter whether it's charged.
Okay.
It won't for the court's consideration.
Okay. Yeah. Just not sure. Okay.
But what do you wish to do?
I mean, I don't. I guess I mean, I admit that there was probably weed on me that was still there. I didn't know that much weed on me. That was still there, and yeah, I don't know about the trespass. I don't know how it comes in.
Well, you had been read trespass before, correct? I mean, you don't have. Pardon?
I never remember that.
So, as the court understands it, correct me if I'm wrong. I mean, you can certainly look at it. That you had been read trespass from University of Michigan properties before.
I think due to this, I guess due to this kid ongoing case, because I have a
Right, but hold on.
They said that it's just this case. I'm
Right, but Mr. Jolly, my point is that you've been read trespass from University of Michigan, right?
Yeah, but I'm in court paperwork with them. I've argued it.
Okay, all right, then let's,
Pretty cool.
all right, you want to go around and round about that? I won't
It's okay.
necessarily go round and round about it. I mean, you admit to violating the substance provisions. You do admit to that.
Correct. And I was at the library.
All right. Pardon?
I was at the library. Correct.
Right. And would you admit that you shouldn't have been on the library property?
Yes. Yeah.
Because you had been trespassed before, right?
From the right. Yeah. All the stuff. Right.
Right? Okay. All right. So you're admitting to those violations.
Right.
I expect everybody to come down. All right. I will accept those admissions to that. Now, you wanted to argue your bond, sir, given the violations?
Yeah. My thing was just that I'm still going through the court process trying to get the trial. I've already done 2 months on this tether. It's done over 2 weeks, done like 15 days so far in jail, and I haven't been to trial yet. So my hope was that with all that time served and not being convicted yet, that I could just go back and to being a regular citizen, treated fairly, and await trial.
All right. And I'll certainly hear from people, but here's the court's concern with releasing you. You originally were released on this case, right? And then shortly after being released, you're in violation of the conditions of your release, right?
I don't know that. This has been 2 months.
Well, you just admitted to violation.
It's been 2 months.
Well, but you just admitted to violations, right? Right?
Right.
Okay. So what tells me that if I were to release you, that there wouldn't be other violations of your condition?
That's kind of what I'm asking, is that if you could remove the conditions, because I haven't still going through the court process. My thing is I don't have money to.
No, Mr. Jolly, you don't understand how this works. You were released, okay, with certain conditions regarding your release, right? Right?
That's right.
Okay. So you were free to do what you needed to do as long as you abided by those conditions, right? That's where you were.
Right.
Then at some point, you violated those conditions.
Right. It's been 2 months.
Okay, but it doesn't matter. You violated the conditions. Right? Okay. Now, Mr. Jolly, here's the problem. If you think for one moment that even if I were considering your release, that I would release you without any conditions, that's not going to happen.
I'm just trying to.
So then the question becomes, Mr. Jolly, when you say you want me to release you, how can you assure the court that you will abide by the conditions that have been set?
Just the fact that I'm a law-abiding citizen, besides the fact that I'm guilty of this, no proof that I haven't been guilty of this, no proof that I did. Besides this, because ongoingly, I'm a law-abiding citizen, so I guess that for being considered innocent.
Sir, you are considered innocent until proven guilty, but the court also has the ability to set your bond and give conditions. All right. The court initially did that, and you violated those conditions.
Yeah, no, I understand what we're here. I think a lot. I do my best when I get out. That's when I get out. I'm a law-abiding citizen. I do.
Here's what I'm going to do. Was there anything from the people?
A couple of things. So What I didn't realize, and I apologize, but I wasn't reading the report properly the last time we were here. It's 2 events that he's back at the library. So when I was speaking with officers beforehand, they made that abundantly clear to me.
That there were 2 times that he was,
Yeah, then at 2 separate libraries. So I'm not really sure what's going on.
What do you mean? What's going on? Oh, are there things out there again? It was balloons? So there's this filter thing and we're trying to figure out where it comes from. We'll sort that out. But the balloons are pretty, I bet. They were. Okay.
So it's 2 April 3rd at 5:55 p.m. He was there. He was looking at according to the police report, he was looking at pornography at a public computer that he was suspected of masturbating. I asked the officer who's here to give me additional details about that. And I believe the information I got was that the witnesses believed he was masturbating, perhaps that his pants were in a certain position, that he was rubbing his genitalia underneath his clothes, which is similar to the events that April 5th in the sense that when the police get there, he's not actually exposed, but certainly conducting himself in a way where he's got his chest exposed, his outer layer of pants pulled down. And this is a CSC case. So it's like, well, we take that behavior and then we layer it on with the fact that he's out on bond for assaulting nurses at the U of M hospital, and he's now charged with CSC for his sexual assaults on them. But in response to the I'm a law-abiding citizen, I mean, I'm looking at his criminal history from Florida, I'm looking at his criminal history from North Carolina, I'm looking at his criminal history from Michigan. The majority of what I'm seeing are misdemeanors, but I do have carrying a concealed weapon from North Carolina. There are larceny offenses from North Carolina. And well, there are. I'm looking at them right now.
Sir, hold on.
In Florida, there is a charge of battery, touch or strike. It was a misdemeanor assault, is what I would probably call it here. Resisting obstructing the police, which is clearly listed as a felony. In Michigan, which seems to be his most recent history, it appears that substance abuse is an issue. In 2010, he was convicted of operating while intoxicated. In 2011, there's a minor in possession that is still listed as a bench warrant. I don't know what that's about. Out of the 90th District Court. 2016, retail fraud conviction. 2017, a conviction for use of controlled substance. That looks like it was pled down from a possession of dangerous drugs. Is what it is initially entered at. But all to say that this is not somebody who has no criminal history. This person's criminal history spans across at least 3 jurisdictions. So, Your Honor, at this point, I'm asking you to not release him. I do also have a question, though, however, about the tether.
Yes.
What type of tether? Like, so I don't have notes from the person that arranged him did not put notes in this file. And when I look it up in JIS, I just see that it was tether.
It's not a GPS tether. He's simply on a scram.
Oh, thank you, Your Honor.
All right. Anything else you want to say? At this juncture, I'm going to continue the defendants, given the circumstances of this case. The bond violation has been found, and the defendant's bond will continue as revoked. You were set for, I will review that again, but you're set for preliminary examination in this matter this upcoming Tuesday, the 23rd, so a week from today. Pardon?
Review my bond on that day.
I will look at it after I hear testimony in the case. But at this point, your bond will continue as revoked. Thank you.
Thank you.
One week later.
Court does call the case of the People's State of Michigan versus Cody Jolly.
On behalf of the people.
State your name, sir. All right. Date and time set for preliminary examination. Are people ready to proceed?
That is correct, Your Honor. People are ready to proceed. A few things at the outset. I would ask defendant be reminded of his absolute right to an attorney. For
Yes,
this.
I will get there.
Okay, and I also asked Ms. Gaines to be present if Your Honor would be willing to appoint standby counsel if the defendant does not want to be assigned an attorney. I also am going to make an offer to Mr. Jolly to plead to an added count 3 and 4 of aggravated assault under MCL 750.81A. That is a 1 year and or $1,000 misdemeanor offense. In exchange, I would dismiss counts 1 and 2, which are criminal sexual conduct in the 4th degree, which are 2-year misdemeanors and are $500, and would require registration on the sex offender registry. This is the first opportunity I've had to speak with Mr. Jolly, so I would ask that he decide if he wants to move forward with the exam or if he wants to take that offer.
What's the offer?
The offer is to plead to an added count 3 and 4 of aggravated assault, which is a 1-year misdemeanor and or $1,000 fine.
But what's the suggestion? I mean, that's not a plea. I understand that you're changing the charges, but there's no plea. What's the plea?
That is the plea offer. And then I would dismiss count 1 and 2, which you're currently charged with, which is criminal sexual conduct in the 4th degree. That is the plea offer, sir.
So what's the jail time? A year in jail is what you're offering?
The maximum penalty for that is a year in jail.
There is no plea. So you just want me to
Hold it, Mr. Jolly, Mr. Jolly, Mr. Jolly. No, you're trying to argue. Mr. Jolly, they've offered you, that's an offer. Okay, but hold on, before you just start making these rash decisions, because that's how you're where you are right now. Okay? So first thing I want to advise you is today's the time set for your preliminary examination, and you've elected to represent yourself. I will tell you that having watched you through the various proceedings, I have some concerns about you representing yourself. And but you're absolutely have a right to do so. But I need you to understand that you're charged with 2 felony offenses or high court misdemeanor offenses of criminal sexual conduct in the 4th degree. You understand that, sir? You understand that they're punishable by up to 2 years incarceration, $500 fine plus court costs, mandatory HIV STD testing, and DNA would be, well, DNA was taken upon your arrest. Do you understand that, sir? All right. Now, you understand that there are grave dangers that can occur by you proceeding on your own without counsel. All right. You understand also that I'm not here to play favorites to either side. And so I will not be in a position where I can assist you in any way. I will hold you to the exact same standards regarding court rule, presentation of evidence, and everything along those lines that I would hold the people to. You understand that? You understand that if you wish at any point to be represented by counsel to help assist you in any way, that the court would make sure that counsel would be provided to you. All right. Now, Mr. Jolly, and I'm going to say this, not necessarily part of the admonitions, I'm very concerned that you don't know what the proceeding that you're in right now is.
The preliminary examination, when you told me initially, you told me that when preliminary examination happened, you told me that the two
That what?
the two alleged victims would be here on today's.
I didn't say that.
Okay, so they don't have to be here today?
I did not say that.
They're supposed to be here.
Do you know what proceeding you're in? Okay, let me ask you this. If the people are successful at a preliminary examination, what do you believe happened?
To ask for a request to move on preliminary, I'm also asking for a jury trial today.
Okay, But-
Then I would.
Mr. Jolly, if the people meet the burden, what do you think happens?
Pardon, what?
If they meet their burden at a preliminary examination, what do you think happens at that point?
We'd have to go on to either preliminary or trial, depending on what your decision.
You understand that you're at the preliminary now.
He said it was examination, but if this is preliminary, we can move on to trial. I'm okay with that. I expected there to be two witnesses here today, two alleged victims here today. That's what I expected. And I think that is right according to the way it should have been. I thought that was right. I am asking where the two witnesses are, two alleged victims. Yeah.
Mr. Jolly, I understand you want to get to a certain point. I have concerns about whether you understand what you're doing.
Yes, I do.
What do you believe you're doing?
Trying to get to trial. Proven innocent.
You understand you don't have to prove your innocence.
I understand that you would have to prove, so the courts, whoever the state would have to prove me being guilty beyond a reasonable doubt. And
Mr. Jolly,
we have where are the two alleged victims that were supposed to be here today? Question for the court.
Sir, I'm not sure how the people are going to proceed in their case. Okay? So I'm not going to answer your question because I don't have the answer to that. Do you understand the offer that the people have made to you? Pardon?
I do understand the offer.
What do you understand the offer is being? Mr. Jolly, do not overtalk me because it will never work. Are we clear? Mr. Jolly, are we clear? Are we clear? Do you understand the offer that the people have made? What do you understand that offer to be?
They said they're dropping from the CSC they're requiring, but they're dropping them to assault. So there's still two charges and up to a year.
But two misdemeanors.
Correct.
That may not have any incarceration with it.
Problem is I didn't do anything. So it's really hard to plead anything. So.
Let me ask you this, Mr. Joe. They don't have to represent you. All right. But would you at least like to talk to an attorney about what that offer means and what risks that you're potentially taking in just outright saying no, as opposed to whatever? Would you at least like to talk to an attorney about that?
I'm just gonna move on. Be honest, I'm just gonna move on.
You're not answering my question. Would you at least like to talk to an attorney? I'm not trying to have you bind to anything, but just to have somebody explain to you what it means. Would you at least like to talk to somebody? I'm not even saying.
Honestly, okay. I'm just upset.
What?
I'm upset with the entire court process.
Okay, you can be upset with the entire court process. I just want to make sure you understand everything that you're doing and to provide you an opportunity to talk with legal counsel to explain this and that. That doesn't take it out of being your decision.
Right.
But at least you can talk to somebody and get more information in making that decision.
And I have no need for it. If you're required, I'll talk.
I'm not requiring you, Mr. Jolly. Quit playing the victim. I'm not requiring you to do anything. I'm offering you an opportunity to talk with a lawyer so that at least everything can be explained to you before you make a decision. Because my concern is that you're making a rash decision, heading forward, not quite understanding entirely what you're doing. You're trying to get someplace, and I don't think you know where you really want to get to.
Thank you. Trial. I thought there was a preliminary to this. There's not.
There's a preliminary today. You understand that?
I would ask for a jury trial.
Okay, that's it. I'm done. I explained to you at the last proceeding when a jury is going to happen and when these proceedings are going to, because at this point, do not overtalk me again. I'm done trying to deal with you. I thought that there was at least some rationality to your thought process and what you're trying to do. I am very concerned about that. I'm very concerned about your competency to be able to stand trial and to head forward. Because you're not tracking what I'm telling you. You don't have to agree with me, but you're not even tracking what I'm telling you. You're off on something else. I thought the last time we were here that was some sort of aberration and not something that is fit you. And I explained to you that we were going to this proceeding, and I don't think you know what proceeding you're in. And you keep saying at times the same thing to me, although I explained to you process-wise how this happens. And so what I'm going to do on my own motion, for good or for bad, but I have to make sure and be sure that this is going to happen. And in light of the activities also of the bond violations, I'm going to refer to dependency on my own motion for competency in this case.
Can I just go talk with the attorney?
And Ms. Willingbrink, if you would be so kind for the court to prepare an order to that respect, I'll set a competency hearing for, give me 60 if we can get it done. We'll have to turn it out.
June 27th at 9 a.m.
June 27th, 2024, 9 a.m. is when I'll set his competency hearing, and I'll look forward to the order.
Question.
Now, do you want, you indicated you want to talk with an attorney.
If you would like me to talk to an attorney instead, that's okay, yeah.
No, it's not instead. If you want to talk with an attorney, Mr. Jolly, I will make sure that that happens. Do you want to talk to an attorney?
You put me through competency then.
No, I'm not putting you through anything. Do you want to talk to an attorney? Yes or no?
Yeah, sure, I'll talk with him, but I don't want to.
Fine. Ms. Gaines, he does not wish to have appointment. Would you assist the court in speaking with Mr. Jolly? I've set it for competency, but maybe he has asked for some legal advice. Can you assist the court in that way, Ms. Gaines?
Yes, sir.
Thank you. So we'll do that. I'll have his bond continue. You can take the defendant back, and Ms. Gaines will be back there to talk to you momentarily, sir.
One more question, just the jury trials.
That's the problem. You don't even understand where you are in the, no, you don't. No, you don't. I'm done. Bye.
Thank you
so much for watching. We really do appreciate you taking the time to watch
this video.
It means so much to us.
So until next time,
Take care of yourselves and each other because we love you.
Well, that was outrageous with a capital O.